Good morning, everyone. You are very welcome to our NUI Galway Law TY Taster Day. My name is Lisa and I am the Marketing and Student Recruitment Officer in the School of Law. Before we begin, I would like to share today's schedule with you. First up, I will present some slides on why study law at NUI Galway. We will then have a taster lecture on the topic of family and Irish law, and we will have a short 15-minute break then from 10:50 to 11:05. After the break, we will have two taster lectures on the law and the consumer and what are human rights, and then we'll have another 15-minute break from 11:45 till 12. And then finally, we will end the day with two taster lectures on what is criminology and robot judges and robot lawyers, oh my. So to get started, I'd like to tell you a little bit about the School of Law at NUI Galway. The School of Law at NUI Galway delivers innovative legal education in a dynamic school dedicated to impactful, high-quality legal research. The school hosts three world-renowned research centres: the Irish Centre for Human Rights, the Centre for Housing Law, Rights and Policy, and the Centre for Disability Law and Policy. And the Centre for Human Rights is heavily involved in our Law BCL and Human Rights course if you're interested in that one. The school is part of NUI Galway, which won University of the Year 2022, and the school was delighted to win Irish Law School of the Year in 2019. The school is ranked in the top 200 in the QS World University Rankings for the subject law. The school offers 5 undergraduate courses, and there are 5 full law degrees, and our 5 full law degrees give students the opportunity to complete all the modules examined in the barrister and solicitor entrance exams in Ireland. So if you wish to become a barrister, you would go on to study with the King's Inn, or if you wish to become a solicitor, you would go on to study with the Law Society of Ireland. So we have our Law BCL, which allows students to maximise their understanding of the legal process. And then we have our law degree, which specialises in human rights. And later on today, you will hear more about what it is like to study human rights. We then also have our Law BCL, Criminology and Criminal Justice degree. And again, we will have a mini taster lecture on criminology later today. And then we have Law and Business, and this course prepares graduates to go on to work as lawyers in a corporate environment. And then we have Law and Taxation. This is one of our newest courses, and it prepares graduates to go on to work in legal practice, taxation, or both areas. We have one graduate who has qualified not only as a solicitor, but also as a chartered tax advisor. And there's a huge demand for law graduates who have a knowledge of tax, as global law firms are expanding their practice in this area. And one of the unique opportunities on the Law and Taxation course is that in second year, once you've completed the taxation module, you will have the opportunity to apply for NUI Galway's tax clinic. And it's Ireland's first free tax clinic. And if you succeed in your application, you will obtain experience working as a clinical tax advisor. There are also other ways to study law at NUI Galway. There's the BA Joint Honours in Law, the BA Government Politics, Economics and Law, the Bachelor of Commerce, and the BA and Human Rights. Now, I suppose these are not full law degrees, but all these degrees offer you the opportunity to study some law modules. So you won't study all the modules required for the solicitor and barrister entrance exams in Ireland. However, if, for example, you take the BA Joint Honours in Law course and you decide afterwards you would like to obtain a full law degree and complete all the modules that are examined in the barrister and solicitor entrance exams, what you could do is, once you've completed 70 credits of law modules and passed the degree, you could enter final year of our postgrad degree called the LLB. So basically, all you would have to do is complete one extra year after the BA Joint Honours in Law to successfully complete all the modules examined in the barrister and solicitor entrance exam. So if you look up the LLB course and go to the key facts section, you'll actually see details about how students from these BA courses and commerce courses have gone on to complete further study doing the LLB. But for the purposes of today's presentation, I'm going to focus on the offerings of our 5 full law degrees. Our School of Law follows a unique and innovative approach when it comes to teaching law. In year 1, we focus on building your skills. In first year, all students complete the mandatory module Understanding the Law. And this module teaches students basic skills such as case analysis. And it also helps students with the transition to the expectations of a university degree. In year 2 then, we develop your skills further through communication and advocacy. And this is done through modules like mooting. And if you haven't heard of mooting before, mooting is a stimulated courtroom experience. It's essentially a mock trial, and students in this module learn how to construct and deliver legal oral arguments. And students have described this module as, I suppose, one of the most scariest things they've ever done, but they've also described it as a transformative learning experience, saying that it's one of the best things they've ever done. So most students will be quite nervous starting this module, but you'll get lots of practice throughout the year. So by the end of the year, you'll be very confident at mooting. Everyone's in the same boat. Lots of students will never have done anything like mooting before. In year 3, then you get to customise your experience by completing either work placement or study abroad. Work placement and study abroad lasts for the entire academic year from September until about April, May. And then in final year, you have the opportunity to shape your degree. So in addition to completing your mandatory modules, you get the opportunity to select a specialist stream. For example, on the Law and Business course, you could choose to specialise in accounting or economics. And then all students have the opportunity to complete a guided research essay on a topic of their choice. And this will help you develop legal research skills, and all students will be assigned an academic mentor for their essay. Moving on then, I have a picture here of our lovely new state-of-the-art moot courtroom. It was designed to replicate the experience of real court hearing for our students. It features a witness stand, judges bench, juries box and senior counsel tables, all made out of natural oak. And the moot courtroom is used for our mooting modules and competitions. Every year the school hosts its own mooting competition. We have a real judge come on campus for the day and conduct a mock trial with students, and the judge basically judges the competition and announces winners at the end of the day. It's a really exciting opportunity for students. And then students throughout the year can go into the moot court and practice their mooting skills. And we also have the Student Law Society, which is one of the most active student societies on campus at NUI Galway. They arrange lots of mooting competitions throughout the year, and they also arrange lots of career events and social events. So if you're interested in the Law Society, you can look up NUI Galway Law Society on Instagram, and you can see some of the activities that they get up to. Moving on then, we have our specialist streams, which are available in final year. On our Law BCL, there are a number of specialist streams available, including business and commercial law, public law, risk and regulation, human rights, crime and equality, and international comparative and transnational law. And all of our 5 law degrees give you the option of studying a language from first year right through to final year. So some of the language options that are available include legal French, legal German, and legal Irish. And if you do law and business, you will also have the opportunity to study Spanish. And then you have on the law and business and law and taxation courses, you can specialise in the likes of accounting, economics, management, and so on. So there's lots of options available. If you decide to study abroad in third year, you can study abroad through our prestigious partner institutions in the following countries: Australia, Austria, Belgium, Canada, China, and so on. And if you study a language with your law degree, we highly recommend that you study abroad in third year through one of our partner institutions who basically offer courses through your chosen language. And if you don't decide to study a European language, you can still study abroad through English. In all of these countries, we have partner institutions who teach through English. So it's not an issue if you wish to study abroad but don't actually study a language. Moving on then, if you decide to do professional work placement, we have a long list of partners and they include Matheson, William Fry, Arthur Cox, and so on. And if you look at our website, you can check out a full list of our current work placement partners. Our School of Law has 2 full-time study abroad and professional work placement officers. So if you decide to complete work placement, you will be supported by our placement officers, and they will provide you with CV and interview skills workshops. And how the process works is that they will basically share job descriptions with you from our work placement partners. And if you're interested in a particular firm or job that's available, they will simply send on your CV to the firm and they'll select some of our students to interview. Some students may apply for only one and interview for only one position and they may get it. Other students may have to interview a few times before they secure a position. But it's important to note that you are supported by our placement officers throughout the whole process. And then students often ask, can I do both study abroad and work placement in year 3? And unfortunately, you can only choose one. But what I would say to students, if you're really torn between study abroad and professional work placement, what you could do is decide to study abroad in year 3 and then try to arrange a summer internship for yourself so that you also get work placement experience. And our students are in a unique position to apply for a limited number of high-profile national and international legal internships. Some of the internship opportunities that our students have completed in the past include working with the Suffolk County District Attorney's Office, the Office of the Attorney General, working in the Massachusetts Office of the Secretary of State, and also working in the Irish Superior Courts. When it comes to careers, there's a long list of careers available with a law degree. Our graduates acquire knowledge and transferable skills that make them highly employable in many sectors. So many of our graduates will go on to become a solicitor or barrister, and others will go on to pursue other careers in the areas of human resources, accountancy, banking, taxation, legal publishing, legal research. And there's also lots of international opportunities working with organisations like the United Nations, the European Commission, the Court of Justice of the European Union, and so on. And if you have a language, there's lots of international opportunities available to you. And some of our graduates have actually gone on to work as EU lawyer linguists. And an EU lawyer linguist is basically responsible for translating new legislation so that it has the same meaning in every European language. And one of our graduates is actually an EU lawyer linguist for Irish. So there's even lots of job opportunities for those who study legal Irish. Some people who study legal Irish may go on to work in a law firm that provides legal advice through Irish. Moving on then, we have a list of some of our graduates. So we have Paul, who is legal counsel in the disputes and reputation team at Revolut. We have Lynn, who is a tax partner at Maples Group. We have Patrick, who is an executive legal officer to the Chief of Justice. We have Connor, who is a public policy manager at Facebook. And then we have Rachel, who is a HR generalist with Shannon Airport Authority. So there's lots of different career opportunities available to you. You don't necessarily have to become a solicitor or a barrister. We've had lots of graduates use their skills that they acquired throughout their law degree to go on to pursue careers in other areas. And I suppose it's also important to note that there's lots of career opportunities in terms of being a solicitor. There's so many different areas you can work in. For example, we have one graduate who is working in the UK, and he is a sports lawyer, and he is working with professional football clubs on the transfer of professional football players. So a huge part of his role actually involves immigration law, transferring players from one club to the other. So I think that role is quite interesting and something that you might not actually think of when it comes to being a solicitor or a solicitor. Moving on then, when it comes to subject entry requirements, if you're interested in studying with us in the future, the subject entry requirements for a Law BPhil, Law BPhil Human Rights, and Law BPhil Criminology and Criminal Justice courses are as follows. So you must have a minimum grade H5 in 2 subjects and passes in 4 other subjects at 06 H7 level in the Leaving Certificate, including having Irish, English, another language, and any 3 other subjects recognised for entry purposes. The entry requirements for our Law and Business and our Law and Taxation courses are the exact same. However, you must also have a pass in ordinary or honours maths. And for those of you who don't study Irish or another language, unfortunately, these are essential entry requirements. However, if you have an exemption from the NUI in Dublin, then you do not need to have Irish or another language. So if you look up nui.ie, it will give you details on who is eligible for an exemption from Irish and another language when applying through the CEO. And some of you might be wondering then, what subjects should I pick for the Leaving Cert if I want to study law? And all subjects will help develop your skills. Like for example, if you choose maths helps with your logical thinking skills, solving problems, and this will be a key skill of a good lawyer. But I suppose one of the most essential subjects for studying law will be English, as you need to be good at reading and writing. You need to be able to read about cases, and you need to be able to deliver your arguments both orally and in writing. And then some other useful subjects would be the likes of history. History involves skills where you have to read large amounts of information and assimilate it. And again, this will be a key skill of a lawyer. And then you have subjects like politics and society, which help you to understand how the government works and how public policy can be improved. And again, this would be good knowledge to have for studying law. And then languages also offer lots of useful skills, and a second language is required for our law degree, so that's quite important. And then if you're interested in studying law and tax or law and business, you may also consider studying business, economics, or accounting. Now, it's important to note that the modules I've listed here are not essential to studying law. The only ones that are essential in the subject entry requirements are English, and then having Irish and another language. So there's no need to worry if you don't want to study history or politics or business, economics and accounting. I recommend that you study the subjects that you are most interested in. And then finally, I would like to tell you about our Terrace O'Malley DLA Piper Scholarship. This scholarship supports scholars throughout their 4-year law degree to the value of €2,500 annually, totaling €10,000 per scholar. The scholarship is awarded to 2 first-year students who are enrolled in one of our 5 law degrees, and is awarded based on financial need and academic merit. The scholars will preferably have a home address in Mayo, but consideration is given to applicants with a home address in the west of Ireland, all counties in Connacht, plus counties Donegal and Clare. Last year, our scholars were from Clare and Galway, and this year we have 2 scholars who are from Sligo. If you want to find out more about this scholarship, you can visit our website at nuigalway.ie DLA Piper Scholarship. And if you'd like to find out more about the law school, you can do so by visiting nuigalway.ie/law. And if you have any questions after today's taster sessions, you can email me directly at lisa.doran@nuigalway.ie, or you can contact law@nuigalway.ie. You can also follow us on Instagram at NUIG Law, Facebook at School of Law, and Twitter at NUIG Law. So I've flown through that presentation, and I think my next colleague is almost ready to join. So my next colleague that is joining is Dr. Brian Tobin, and Brian will be presenting the first taster lecture on family and Irish law. Brian is the Programme Director for the Law BCL and teaches the module Family Law. Brian's research interests are in family and child law, and he has contributed to policy development in donor-assisted human reproduction and surrogacy. So I'll pass you over to Brian and I'll chat to you all later.
Okay, so hi everyone, I'm Brian and I'm the Programme Director for one of the law degrees, the Bachelor of Civil Law degree. And I'm also one of the lecturers for first years. So I lecture family and child law to first year students. Tends to be a subject that the students enjoy an awful lot, and hopefully you will too if you decide to join us. For some reason I can't see the slides, so can anyone help me out with that? I can't see them. I can just see TY Taster Days.
Okay, maybe just stop your share again and we'll start again.
Okay. So stopped, and yeah, I don't seem to. Okay, I'm not sharing anything now at the moment. They're open, but the thing is not giving me the.
I'm going to share here, okay?
Yeah, okay. So I'll maybe tell you to move between them or something.
Yeah.
Okay, they look different. Okay, so there's a slide. So we're going to speak just about very briefly this morning, I'm very busy, about the family and Irish law. So what you'll be learning about in first year is what constitutes a family under Irish law. And what you'll find is that what we call the basic law of the state, you might have heard of it on the news many times, the Constitution, that defines what a family is. And it might come as a surprise to some of you that even now in 2022, the Irish Constitution only recognises families based on marriage. And can we move to the next slide, please? And that is because it's provided in Article 41 of the Constitution that the state pledges itself to guard with special care the institution of marriage on which the family is founded and to protect it against attack. So only married families are recognised under the Constitution because, as you can see from that explicit article, it speaks about marriage on which the family is founded, which indicates to us that a family cannot be founded, at least according to the Constitution, under anything else, so under cohabitation, for example. Now, you might say, well, that's really restrictive. That article is from 1937. It's one of the original articles in the Constitution. There have been recent calls for reform, so you might note that we've had a number of citizens' assemblies in recent years. And the most recent one did recommend that we might have a referendum to amend Article 41 so that it protects all family units and not just the marital family unit. Now, whether there would be the political appetite to put that to a referendum remains to be seen. But for the moment, we have a situation are protected and families recognised under the Constitution. That can have implications, which is something that we will debate in further and flesh out through the year. And this morning is a very, very brief overview of all the different stuff we would do in family and child law. Next slide, please. So some good news is that at least our definition of marital family is broader than it was, because although you might have been a little young at the time, it is 7 years ago now, there was a marriage referendum in 2015, which was successful and which inserted a new, basically an add-on article into Article 41, Article 41.4, and that provides for marriage between two persons, any two persons, without distinction as to their sex. And what that means is that two persons of the opposite sex or now the same sex can marry according to the Constitution and be recognised as a married family unit under the Constitution. So as I say, since 2015, both opposite sex, i.e. male-female, and same sex, female-female, male-male, married families have been recognised by Article 41. That was quite a big change, occurring, 78 years after the enactment of the Constitution to finally embrace a broader type of married family unit. But you might say, well, it still only embraces married family units. That is true. We'll look at some other units in a few minutes. But I suppose what I would say to you now is that, maybe just the next slide, please. Your married family now can look like this. So it can be an opposite sex married family unit. It can be a same sex married family unit, like the images there on the slide. Male-female family, male-male, female-female. Of course, our families can be mixed race, etc. So we can have all types of married families now recognised and protected under the Constitution, which shows that we've become a more progressive society as well. Now, you might see from the images there that all of the family units that I uploaded, they all have children in the images, and that's a big thing we'll explore in child and family law, is the rights of children, because actually they can differ. And I'll just give you a brief overview. So the first image is the very simple one, the man and woman there with the baby. That could, in most cases, be what we call traditional procreation. However, couples like that may need to engage a donor, whether a sperm donor or an egg donor, engage in some form of IVF or indeed surrogacy. The male-male couple there with the child as well, the only way they can bring a child into their family unit is through surrogacy, essentially. Now they can of course adopt a child as well, but ordinarily if they want to bring certainly a younger child or a baby into their family unit, they would have to engage a surrogate, because essentially male same-sex couples cannot procreate without the assistance of a surrogate. Although, as I've said, in some instances a surrogate might be required by a male-female couple too. Now the couple on the bottom then, they've got quite a big family, haven't they? They've got like 3 children. So that's a female-female married couple, let's say, and they would need the assistance of a gamete donor, sperm donor, essentially, to procreate. Unlikely they would need the existence, the assistance of a surrogate, because it's highly unlikely that at least one of them would be able to carry a child to term. Now, in some very rare instances, female-female couples might need to engage the assistance of a surrogate, but in all instances, they will need to engage a sperm donor. So there's different ways children are brought into, different types of family units, married or otherwise, and actually their rights can differ as well, depending on the form their parents' union takes, and that will become a little clearer as we proceed through first year. Just the next slide, please. So you might say then, what of cohabiting families? You talked about this thing, the Constitution, that I sometimes hear about on the news, and that it only protects married families. That's true. It does not recognise family life going beyond marriage. However, that does not prevent the Oireachtas, as you know, our Parliament, from enacting laws to recognise and protect the rights of cohabiting couples and other types of unions. So while they're not recognised by the Constitution, yes, cohabiting couples have certain rights in relation to one another under legislation enacted by the Oireachtas. Okay, so legislation essentially is an act of the Oireachtas passed by the Houses of the Oireachtas, signed into law by the President, and then it becomes law at that point. You probably often hear that on the news as well, that today the President signed into law the X Act 2022 or what have you. So this one is called the Civil Partnership and Certain Rights and Obligations of Cohabitants Act 2010, and that is a very long title. I'll show you how to abbreviate it for exam purposes, but just to say that it's the second part of that act I'm just going to focus on for a moment this morning. It's the Certain Rights and Obligations of Cohabitants Act 2010, because sometimes people sit up and think to themselves, oh, what's going on here? Like, you know, I'm just living with someone. I'm 23. I live with my girlfriend. You mean we have certain rights and obligations? Not necessarily. It's technical. It's not really similar to marriage or anything like that. But yes, if you live with someone long enough and that person is financially dependent on you, they may seek remedies from you upon termination of the relationship. So actually, sometimes, in limited circumstances, when a cohabiting relationship breaks up, the less well-off cohabitant may seek remedies from the other cohabitant, and they can be, maintenance support. They may seek, pension adjustment orders, things like that. The simple rule, and again, we discussed this a lot more as you would proceed through the year, but the simple rule is that where a cohabiting couple has a child together, if they've been living together for 2 years or more and the relationship breaks up, well, then the financially dependent cohabitant can seek remedies from the other cohabitant after, as little as 2 years where they have a child together. Now, where a cohabiting couple are living together but don't have any children, then the minimum period they must be living together is 5 years. And if the relationship breaks up after 5 years, the financially dependent cohabitant can seek remedies from the other cohabitant. So in some circumstances, yes, cohabiting families are granted rights in relation to one another by legislation. The other thing to note that there's other types of legislation that have been extended to cohabiting families by virtue of this legislation and subsequent legislation too. So things like barring orders or protection orders that might come under our domestic violence acts. I don't want people to think this morning that just because the Constitution says marriage and marriage only, that if you're cohabiting, you can't seek very serious remedies like that. Yes, of course, the remedies under the Domestic Violence Acts have been extended to cohabitants and been improved upon as recently as the Domestic Violence Act of 2018, such that they don't have to be living together now for any minimum period anymore before they can seek remedies for domestic violence. Before, there was they had to be living together for something like 6 out of the previous 9 months, which could make it difficult if the relationship broke down and a certain order was needed when the relationship broke down less than that period of living together. The next slide, please. So what about the rights of children born into different types of families? Well, it's very simple if your parents are married. Simple but complicated, because if your parents are married and are of the opposite sex, you'll have a mother and a father, and they are both automatically recognized as your parents and guardians when you are born. So children born into what we might call traditional opposite sex marital families, well, their parents, their mother and father, are automatically by the law recognized as parents and guardians as soon as the child is born. So it's very simple. They have all the rights they need to take care of the children once the children are born. A guardian, by the way, you might actually receive forms from your school to be signed by your parent or guardian. And this can be a little complicated too, because parents are often guardians, but not always. Other people can be your guardians if, for example, your parents can't be. But, you know, often parents are guardians, and it's important for someone to be your guardian, because a guardian is the person who makes the big decisions in relation to a child's life, essentially, all the big decisions about medical care, where you're going to go to school, where you're going to reside, etc. Now, it's more complicated. You might say, what about a child born to married parents, but married parents who are of the same sex? Actually, only in some instances will such a child have its parents recognized as A, parents, and B, guardians, because this is where it gets a little complicated. Children born to, let's say, married male same-sex parents, well, obviously they'll have used the assistance of a surrogate. And you might be aware that at the moment, we don't have any law regulating surrogacy in Ireland. You might be aware from the news a little bit that there is currently a special Oireachtas committee considering all of the issues surrounding, in particular, international surrogacy arrangements, because 99% of people go abroad for surrogacy. They pretty much have to. So if a child is born to a male same-sex married couple through surrogacy, the surrogate is recognized as the mother and guardian at birth. Okay, so it's more complicated. And how do we relieve her of these rights? Well, the long and the short of it is, at present under Irish law, one can't. Okay, the surrogate remains the mother and a guardian of the child. That's how our law sees it. Whether that will change in the future really depends on a pretty lengthy process, which is started now by this special Oireachtas committee. When a child then is born to female same-sex married parents, you know, it's co-mothers, we might say, they can both automatically be recognised as parents and guardians, because since 2015, children born through donor conception, which is the method female same-sex couples would use, so where they get a sperm donor, you know, and this is all done through what we call a DAR facility, donor assisted human reproduction facility, i.e. a fertility clinic. They sign various consent forms. The donor waives any parental rights, again under consent forms. And by virtue of that legislation, when a child is born through donor assisted human reproduction to female same-sex married parents, they can now both be recognised as parents and guardians when the child is born. Now, when children are born to unmarried parents, irrespective of whether their parents are of the opposite sex, the same sex, what have you, it's more complicated. The mother is automatically recognised as a parent and a guardian, but the father has to take further steps to be recognised as a parent and a guardian. So people are often not aware of this, you know, even, you know, cohabiting unmarried parents often think that once a child is born to them, that from the moment it's born, well, you know, I'm its mum and I'm its dad. Not necessarily, no. The father actually only becomes recognised at the point of birth registration. So once the father's name is placed on the birth certificate, what we call the presumption of paternity applies to him, and the unmarried father will be recognised as a parent, but not a guardian. And there are various further steps that he has to take to be recognised as a guardian. And it's all quite complicated, which we're not going to go into this morning, because there's actually 4 different ways he can be recognised as a guardian, and they're all quite technical. But for me, that for the moment, as you can see from the slide, children born married have a different set of rights, or even, you know, less rights when they're born to married parents at the time of birth. And a lot of people also think that once the father's name is placed on the birth certificate, he acquires guardianship in relation to, you know, the child. you simply acquire a presumption of paternity that, you know, by placing your name on the child's birth certificate, the law will presume you're the father, but that does not make you a guardian and does not entitle you to make any big decisions surrounding the child's life. Again, people are often surprised by this. There's something of a myth out there that, you know, an unmarried father's name on the birth certificate grants him every parental right needed. Not true at all. Next slide, please. Okay, so we've touched on this a little bit. What about children born through surrogacy? And as you're probably getting a flavour from this very brief introduction, wow, you know, there are so many different types of family and ways children can be born into families, and, you know, their rights can differ depending on, you know, the method of conception. So there is the Health Assisted Human Reproduction Bill 2022, which is currently proceeding through the Houses of the Oireachtas. It was only published less than 2 months ago in March, and it provides for domestic surrogacy. So if it's passed, again, I don't expect you to be familiar with this, but you might have some general knowledge that, you know, a bill must be passed by the Houses of the Oireachtas and signed into law by the President to become an act. At that point, it is law. So if this bill becomes law, and it is expected that it will by the end of the year, we will have laws regulating surrogacy that takes place in Ireland. That's what I mean by domestic surrogacy, so at-home surrogacy here in Ireland. The big problem with the bill is it does not regulate surrogacy that takes place abroad, which again is a very difficult thing to do, because how can we you know, regulate what happens in other countries, other jurisdictions? And that is why currently the Joint Oireachtas Committee on International Surrogacy is meeting to help decide if we can enact laws to regulate the parentage of children born to surrogates abroad, born to, you know, Irish parents, via the use of, I suppose, a surrogate mother abroad. So very complicated situation. You know, we might have domestic surrogacy soon enough. International surrogacy will be trickier. There are a lot of issues surrounding international surrogacy as well. So just to kind of put it out there, one of the big things about international surrogacy is that it's international commercial surrogacy almost everywhere, in that a fee is paid to the surrogate for I suppose the act of gestating the child for the intended parents. And that can cause problems because there's international law which says that actually international commercial surrogacy has to be tightly regulated to ensure that people aren't being exploited or what have you. So it's a bit of an uphill battle. I suppose the problem is that there are many children, hundreds of them, living in Ireland who were born through surrogacy abroad. And at the moment, they only have, many of them, one legal parent because, as I said earlier, the surrogate is recognised as a parent under Irish law. So even though she might be in India, Thailand, wherever, you know, that's what our law recognises her as, because she gave birth to the child. It's a principle called mater semper certa est. Mother is always certain, i.e. the woman who gives birth to a child is its mother. So how we can get around that and allow what we call the intended parents, i.e. the people who, you know, through the surrogacy arrangement actually intend to parent the child, how we can allow them to be recognised in law as parents is something that will have to be teased out in the bill and the parliamentary debates, and of course by the Special Committee on International Surrogacy. By the way, we'll spend about 6 weeks on this alone in Child and Family Law in first year. It is huge, massively complex, generates loads of debate. Students usually find it really interesting. So hopefully if you join us, you will too. And we'll go on to the next slide, please. I think we're almost there now. So just finally then, briefly as well, yes, the family has rights not only under Irish law, but internationally under this instrument, the European Convention on Human Rights of 1950. Under Article 8, everyone, that's all of us, has a right to respect for private and family life, our home and our correspondence. Under Article 12, men and women of marriageable age have the right to marry and found a family according to national laws governing the exercise of this right. You'll note that Article 12 refers to men and women, and believe it or not, even though it's in many ways a progressive human rights instrument, the European Convention on Human Rights does not yet provide for marriage between same-sex couples. It only provides for opposite-sex marriage. So I think I'm just within time, Lisa. Quite neat, actually. So thank you all for attending. Enjoy the rest of your day and your taster session and all of that. And think about joining us for Law at NUI Galway, where we can explore and debate the many issues touched upon this morning a whole lot further. Thank you very much.
Thank you very much, Brian. We will now have a short break from 11 until 11:05. So you have about 15 minutes now. And after the break, we will have 2 more taster lectures on the law and the consumer and what are human rights. So we'll see you in about 15 minutes. Thank you. Hello everyone, welcome back to our Law TY Taster Day. Our next couple of lectures will include the opportunity for you to participate in a poll. You will essentially be asked to answer some questions online where you'll be given multiple answers. So if you have access to a mobile phone or laptop, that would be great. If you don't have access to a mobile phone or laptop, that's fine. Maybe if you're watching this in the classroom, maybe your teacher might answer the questions on your behalf. So next up, we have Dr. Katrina Gardner. Katrina's research interests are primarily in commercial and consumer law. Some of her research has focused on e-commerce and the challenges presented by the growth of online retailing for consumer protection. Katrina has lectured on many subjects, including international trade law, company law, business law, commercial law, and consumer law. And Katrina's topic today is on the law and consumer. So I'll pass you over to Katrina now.
That's great. Thank you very much, Lisa. And it's great to be here today, and I'm delighted that so many of you could join us for our Taster Day. So as Lisa said, my area is really commercial law and consumer law. I mainly teach second years, and I also teach on our master's program. So I thought today that I would talk to you a little bit about my area of interest research-wise, which is really consumer law. And this is one of the great things I think about studying law at university, is that really you get to dip your toes into lots of areas and find yourself researching in lots of very interesting and different areas. Like if you take today, for example, you're getting a little taste of maybe family law, a taste of human rights law, a taste of criminology, even robots and the law. So you can see sort of how many different and interesting, diverse areas there are to end up researching in or practicing in when you choose law as a discipline at university. So today I'm going to talk to you about my area, as I said, which is consumer law. I don't seem to be slides here. Sorry, and just give me a moment now, and I'll try to resolve this. Sorry about this. I'll stop presenting for the moment, and I'll just try and share again. Let me just see if this might work now. I hope that's working now. So yeah, the interesting thing about consumers is that, and consumer law as a discipline, is that we're all consumers. So it affects us all on a daily basis, in fact. Really, a consumer is a person who buys goods or services for personal use. So really, that applies to all of us. We all enter into transactions for the purchase of goods or services every single day. Some of the things that we buy and use are really things that we need, like food and clothes and things like that. And some of the things that we buy are what we would call luxury goods, which we don't really need, but which are really make our lives kind of richer, like things to in terms of entertainment, in terms of like furnishing our houses, and we all have social media subscriptions. All of these things that we do on a daily basis are consumer transactions. And in fact, they're all contracts. So that's how the law applies to all of these transactions, because every time you enter into a transaction like a purchase of a Netflix subscription or something like that, that is actually a consumer, that is a contract. And it contains terms and conditions that are going to be binding on you, as contracts always are. It's a binding promise. So because of this, because we're entering into binding contracts, consumers need to be protected by the law. And the reason for that is because, unlike maybe business to business contracts where people are on an equal footing with each other, when you're in a situation of a relationship with a consumer and a business, the business is the one that has all the power and all of the information. So there is a lot of imbalance, and that's why consumers need to be protected by the law, because there is this imbalance of power, of information, and of resources that applies to all these transactions that we enter into. And the consumer is always seen to be in the weaker position in the relationship. So there is this imbalance, and that's why the law has to step in to protect the consumer. So the big business has all the power in the relationship. The big business is the one who writes the terms and conditions. The big business is the one that has all the resources in terms of marketing and advertising to lure you in to purchase their particular goods or services. And then if there's a problem with the transaction, the big business is the one that has all the resources to fight in court, whereas the small consumer might not be able to do that. So for all of these reasons, the law has to step in to protect the consumer. You can just imagine the power imbalance that there would be between this small consumer here on the right and some of these big companies like Google and Coca-Cola, Starbucks and Amazon, massive companies that have all this power and resources. So consumer law is very important for us to protect us. And there are lots of ways, in fact, that big business may have the opportunity to take advantage of the smaller consumer, such as me or you. So the law steps in and protects us from all sorts of practices that would be considered unfair, such as things like unfair or misleading advertising, putting unfair conditions into the contract, selling products that are defective, even selling products that are dangerous, dubious marketing practices, lots of things that the law has to protect us from. So from that point of view, consumer law is a really interesting subject and throws up some very interesting cases to deal with. So what I thought I'd do, first of all, I suppose, is because consumer law is really all about ensuring that protections are put in place for us, one of the most important things is that consumers are aware of their rights. So it's no good having all of these consumer rights and consumer protections if, in fact, consumers are not sure what those rights are, then they cannot really avail of them. So I thought a fun thing to do would be maybe to try a little poll to check for just a few questions for the audience here to see how well do you know your consumer rights. So we can do our own little survey and find out how much we know. So if you want to get your phones out here, I have a poll up here that asks you a question. And what you can do there is try and join this poll, and by clicking on the slide here with your phone. I know that a lot of you mightn't have phones with you today, but we'll see if there might be some that can join in. So the question here is, you buy a coat in a shop and the next day you decide you don't like the colour, which happens to a lot of us. It mightn't fit, or you don't like it, or you've changed your mind, whatever it might be. So you go back to the shop. Now, what must the shop do here? Must the shop give you a refund, or must the shop give you a credit note? Or is the situation that the shop does not have to give you a refund or a credit note? So what is the law here? And does anybody know? So I'll just give you a moment there to try and answer this question. And then we'll have a look at the answers, and hopefully it will be working. Oh, it's working. Okay, so lots of you have answered here, and you've answered, 71% of you have answered to say that the shop does not have to give you a refund or a credit note. We've got 13% saying the shop must give you a refund, and we've got 13% saying the shop must give you a credit note. Well, the 75% of you here is correct. Oh, it's gone up to 80% now because we've talked about it a little bit, so that's good. Yeah, the answer is that the shop doesn't have to give you a refund or a credit note. And in fact, that is something that is quite widely misunderstood, because in fact, most big stores, like if you go into Dunnes Stores or if you go into Marks and Spencer's, they're quite happy to give you a refund if you change your mind, and that's their store policy. So, you know, people tend to think that that is the norm and that is required by law, but in fact, that is just a store policy. And if there's nothing wrong with the coat, if it's not defective or faulty, then in fact the shop does not have to give you anything. They don't have to give you either a refund or a credit note. So well done to those of you who got that answer correct. So let's try another one. So this is a different question now. It might be a little bit more tricky. So you bought a new laptop and 1 week after you buy it, it crashes. So it develops a fault, but then you think, oh my God, the guarantee period has expired. So it's only 1 week since the guarantee period has expired. And a lot of us would think at that point, well, that's the end of it. We've no consumer rights. So let's just see, what do you think here? Do you have no consumer rights after the guarantee has expired? Or do you still have consumer rights because the guarantee does not affect your statutory rights? Or thirdly, if you've registered the guarantee with the manufacturer, you will still have consumer rights. So again, just take a moment and we'll see if you can answer that. See what the answers are to this question. So let's have a look. Yeah, so it's a bit more mixed here. The answer is a little bit more mixed. So yeah, the correct answer to this one, and most of you have got this again, 58%, you still have consumer rights as the guarantee does not affect your statutory rights. That is the correct answer to this one. And again, it's something that's quite often misunderstood. People tend to think that the manufacturer's guarantee is the same as your legal rights, when in fact it isn't. So even if your guarantee has expired, you can still make a claim against the retailer there. If, for example, the laptop is faulty and you can claim that it's not of merchantable quality under the law, or that it's not fit for purpose under the consumer law. So your guarantee is completely separate from the law. So again, that's something that some people tend to misunderstand. And that's why it's so important to have information campaigns to make consumers aware of their rights. So I thought I would next have a look at my particular area of research at the moment, which is all about, I think it's a very interesting topic. Of course I would, because I'm conducting a lot of research into it, but my particular area is about terms and conditions that we enter into when we enter into online contracts. So all of us have done this, I guarantee you. Whenever we're entering into a contract, maybe you're signing up for a social media subscription, like maybe you're joining up to Instagram, or maybe you're joining up to Snapchat, maybe you're buying a Netflix subscription, maybe you're just buying clothes online from ASOS or one of those kinds of sites. There are definitely going to be terms and conditions attached to your transaction. But the thing is that the vast majority of people will tick this box. You see this kind of box here on the right that says, please indicate that you have read and agreed to the terms and conditions. So the vast majority of people will go straight away and click that box, and they won't bother to read the terms and conditions. So this has been called the biggest lie on the internet, because everybody ticks that box that says, I have read and understood the terms and conditions, even when they haven't. So you might think, well, what's the big deal? Why would we need to read the terms and conditions? Before I look at that, we might have another little poll here, just to confirm how many of you actually do read the terms and conditions when you're purchasing goods or services online. So let's have a little poll here, which I'll leave you a minute. 100% so far, and that's really not surprising, because nobody reads the terms and conditions when they're entering into a purchase, and this has been proved with some experiments that I'm going to talk about. But you might think, well, what's the big deal? And sometimes it's fine, obviously, that the transaction will go ahead and you'll get your goods and your services and there'll be no problem. So that's great. However, it's only when the transaction goes wrong and you realize that you didn't read the terms and conditions, and when you go back to check them, there's a problem, because maybe it might be the case that you bought this laptop computer that crashes after a week, and when you go back to read the terms and conditions that you didn't read in the beginning, it says something like, in the fine print, it says, "We don't accept any liability for any defects whatsoever." So that gives you no right of redress there at all. You can't do anything then, or you think you can't. Or it could be something like, "We disclaim liability for any injury caused by the product." So that would rule out any personal injury claim if you happen to be injured by a defective product. Or, and this is a very common one, it could be that any disputes or complaints must be brought before the courts of California. And you're thinking to yourself, hang on a second, I just bought this online, and I didn't realize that I'd have to go to California if there was a problem, and I can't afford to take a case to California, and that's the end of that. So you just think, oh no, and you think I can't do anything about that now. So there could be a problem afterwards once you go back and check the terms and conditions. The thing is that it's a very, very common thing that absolutely nobody reads these terms and conditions. And some companies have done some fun experiments to try and test this. The well-known computer games company, GameStation, did a fun experiment to highlight the extent to which people don't read their terms and conditions. So what they did was they put what they called a kind of a spoof clause into their terms and conditions, and they did this on April Fool's Day. And they said that in the terms and conditions, it said anybody buying goods from them on that day and not clicking on the link would in fact forfeit their soul to the company. So you can see there on the right, this is what the terms and conditions said. So you were granting GameStation a non-transferable option to claim for now and forevermore your immortal soul. And if you did happen to click on the link, it would bring you to a page that said, "This is an April Fool's Day joke, and well done for finding this clause and offering you a £5 voucher." But in fact, 7,500 customers on that day signed up and bought games from GameStation, and none of them found the clause. None of them clicked on the link. So it shows really that this experiment highlights that really nobody at all reads the terms and conditions. There was another one, another example, which was a company called Purple that offers free Wi-Fi services in public areas, and they also added a spoof clause to their terms and conditions, and they ran this experiment over 2 weeks. And anybody who signed up for free Wi-Fi during that time was presented with terms and conditions that contained a clause that they would agree to 1,000 hours of community service. And that community service included all sorts of things like cleaning up dog poo, providing hugs to stray cats and dogs, cleaning up portaloos at festivals, a funny one, painting snail shells to brighten up their existence, and scraping chewing gum off the streets. So 22,000 people signed up to this clause with no problem. And so the company made this public as a kind of a publicity thing, and it was as another good experiment to show the extent of non-reading of terms and conditions. So this sort of leaves us with a problem. So if you're looking at this from a law point of view, and looking at the problems for consumers, we have to ask the question, if it's important to read the terms and conditions, why do people not read them, and what can we do about that? Is there anything we can do to redress this situation? Well, the reasons have been researched as well, and the reasons that people don't read the terms and conditions are because they're always too long. There is an example of Amazon Kindle's reader, its electronic reader. The terms and conditions, when you sign up for that, contain 73,000 words. And it has been proven that that takes 9 hours to read. There was an experiment, the Consumer Association in Australia asked an actor to read the lot of those terms and conditions, and it took 9 hours to read, and it's all on YouTube if you wanted to have a look at it. So the terms and conditions are also too complex, and really people just want to get on with their purchase. So I'm just going to finish up with this because I think I'm nearing the end of my my time here. So Excuse me, how the law can help with this problem. Well, the law can help really. We have this directive, it's a European directive called the Unfair Contract Terms Directive. So this directive says that terms and conditions have to be transparent and have to give consumers a reasonable, excuse me, a reasonable opportunity to access them. But the various experiments obviously show that consumers really won't read the terms and conditions, no matter how transparent and accessible they are. So in addition to that, this law provides that the terms have to be fair, excuse me, and balanced. And if they're not fair and balanced, then they won't be enforceable against the consumer. So we have a double kind of layer of protection there. And in fact, if you notice any unfair terms and conditions in your contract, and I hope from now on that you might begin to look out for them, you can in fact report them to the CCPC, which is the Competition and Consumer Protection Commission. So that's something that you can do to take action to report terms and conditions, and then the CCPC can investigate that. So that's how, in a nutshell, really, that we guard against these terms and conditions that are so long and so complex that people don't read them. So we now need to ensure that these terms and conditions are fair and balanced. So I hope that's given you some kind of a taster. There's lots of different areas of consumer law that are really very interesting, but I hope that's given you some kind of a taster of what consumer law is all about. And thank you very much. Now I'll hand you back to Lisa. And thank you, before I lose my voice altogether.
Great, thanks very much, Katrina, for that very interesting taster lecture. Up next, we have Dr. Naomi Magulini, who is going to present a taster lecture on what are human rights. Naomi completed her PhD at our Irish Centre for Human Rights on the topic of trafficking in human beings, gender and the asylum determination process. Naomi is now the Programme Director of our Law BCL and Human Rights and lectures on the modules European Union Law and Competition Law. So I'll pass you over to Naomi now. Thank you.
So it's a pleasure to be here. Thank you, Lisa, for the kind introduction. As you said, I now teach EU law and competition law, even though in the past and in my PhD research in the first place, I've been dealing quite extensively with human rights law, with international migration law, and international anti-trafficking law, especially. Alongside lecturing in law, I'm also involved quite heavily with transnational lawyering, which some of you might wonder what that is. It's basically taking a human rights claim to regional or international bodies, so not through domestic courts, but to the European Court of Human Rights or United Nations treaty bodies, but we will come back to that later on. I just wanted to start by saying that because human rights is an area that is heavily interdisciplinary, intersectional, there's no one path towards working in human rights. And I can surely testify to that in the sense that my own road to human rights has not been linear. So I started studying political science and international relations. I almost had an obsession with statistics at the time, and then it turns out that my true passion was law, and within the wide spectrum of what is law, my very true passion and commitment was towards human rights. But what are human rights? That might sound like a superficial question in a sense, but human rights have a very, very long history. And the nature of human rights, the origin of human rights, is actually in philosophy rather than in law. And philosophers used to ask questions such as what makes us human? What are the claims we are entitled to make as humans? Are we as humans entitled to a particular treatment? Are all humans entitled to such treatment on equal footing? So some philosopher would argue that the capacity to reason is what makes us human. Other philosophers relied on religion and argued that because we're all born in the image of a god, we have entitlements for religious reasons. Other philosophers then argued that our universal needs unite us in the category of human, and that there are rights corresponding to such needs. Now, in addition to being a philosophical idea, human rights later became, and crucially still are, a political idea. So rights as a political idea came to the fore really during the Enlightenment period in the 18th century, with the French Declaration on the Rights of Men and Citizens in 1789, and with the United States Declaration of Independence in 1776. The notion of human rights then was linked with our unique human nature, which meant that because we reason and because we want to self-determine, we should be governed in a democratic setting through a social contract with the people, on the one hand, consenting to be governed, and with the state having to limit its powers vis-à-vis the people. So the 1789 and the 1776 declarations contain some similar concepts, that all humans are created equal, that we have certain inalienable rights, and that the state shall refrain from interfering with our rights. And at the time, those rights were codified really as the right to liberty, freedom, property, fair trial, and the prohibition of torture. But the first rights to be crystallized were what we now call rights associated with negative obligations. They were civil and political rights. In other words, what does negative obligation mean? It means that the state shall not interfere with our rights. It shall refrain from taking action against our entitlements. But the path, and arguably an obstacle course, towards human rights as we know them today had just started with these types of negative obligations. Over time, other rights were added to the catalogue of human rights, rights that spoke to positive obligations of the state. So rather than talking about the state not interfering, these rights talked about the state proactively facilitating access to certain rights, and in particular economic, social, and cultural rights, including, for example, the right to education, the right to healthcare, the right to housing, fair conditions of work, until the right to a healthy environment, which is part of what is called or known as new rights or third wave of human rights. But what was the aim of these obstacle course? What was the end game in this process of human rights achievements? So some would argue that the main aim was to achieve justice, equality, and dignity. And so far we've talked about human rights as a philosophical idea, as a political idea enshrined in declarations, or thought about and written about by philosophers and scholars. But we haven't really talked about the law, haven't we? So what then prompted the recognition of human rights as a legal concept? The birth of human rights as we know them today is usually linked to the aftermath of the Second World War. The horrors of the Holocaust resonated vividly with the international community, which condemned the murders of Jewish people, other ethnic minorities, queer people, people living with disabilities, as well as political and religious opponents perpetrated by the Nazi regime in Germany. And while gross violations had happened before the Second World War, mostly outside of the European continent, it was only at that point in time that the international community became invested deeply in the question of human rights. So for the first time, we started to see legal instruments protecting human rights at an international and a regional level, as well as increasingly incorporated into domestic law, including in constitutions. So as the war was about to end in 1945, 50 states gathered in San Francisco and drafted the United Nations Charter, which created the United Nations. The Charter clearly indicated the commitment of states to practice tolerance and live together in peace with one another, and to unite strength to maintain international peace and security, to avoid, in other words, a World War III. In addition, the Charter explicitly made reference to human rights, and in particular, it reaffirmed the international community's faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and of nations large and small. So this was 1945. And 3 years after adopting the Charter in 1948, the United Nations General Assembly proclaimed the Universal Declaration of Human Rights, which contains a catalogue, really, of human rights, including, for example, the right to life, the prohibition of slavery and servitude, the prohibition of torture and other cruel, inhuman, or degrading treatment, the prohibition of discrimination, the right to freedom from arbitrary arrest, detention, or exile, the right to asylum, the right to a nationality, the right to a fair trial, the right to freedom of thought, conscience, and religion, the right to freedom of opinion and expression. And this list goes on and on. Now, while the Universal Declaration of Human Rights of 1948 is not a binding treaty, but rather a declaration, and it has therefore no legal power per se, it has led to the creation of a multitude of treaties with binding force. The earliest were the twin protocols on civil and political rights and on economic, social, and cultural rights, which were then followed by the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture, the Convention on the Rights of the Child, the Convention of the Rights of Persons with Disabilities, and again, could go on with this list for quite some time. The adoption of treaties, however, will not mean that all rights contained in such treaties and that states ratify and therefore bind themselves to respect will be upheld and protected. And this is when the work of human rights lawyers, human rights advocates, and communities become immensely significant. Indeed, while human rights have a long history, a history of fights and protests and resistance, and it might seem that once achieved, they cannot be taken away, we are increasingly witnessing pushbacks and regressions in human rights protection. So this week, for example, a leaked draft opinion of the United States Supreme Court revealed the possibility of overturning Roe versus Wade, a key 1973 decision which guaranteed federal constitutional protection of abortion rights. In April, there have been talks to reintroduce a law in Poland aimed at creating an LGBTQIA+ free zone, a law that was already approved in Parliament last year, but struck down by a court because it was deemed to be discriminatory. During the COVID-19 pandemic, a crackdown on opposition activists and human rights defenders, as well as increased attacks on journalists and moves to curb free speech, have been recorded worldwide. Human rights lawyers, advocates, and communities play a major role in shedding light on violations of human rights, in promoting access to human rights, in defending groups that are targeted, and in holding governments to account. And we also have notable examples of human rights lawyers and advocates and scholars here at NUI Galway. Professor Siobhan Mullally, who is the director of the Irish Centre for Human Rights, is the current United Nations Special Rapporteur on Trafficking in Persons. Dr. Maeve O'Rourke, who has represented victims of historical abuses in Ireland before the Irish Human Rights Commission and numerous United Nations human rights treaty bodies, are just some examples of the human rights lawyers, advocates, and scholars that we have at NUI Galway. And as human rights lawyers, advocates, and scholars, we are inspired by people that came before us, that are working alongside us today, and we're very much looking forward to working alongside colleagues of the future. So young students that will lead other waves of change, that will join the human rights movement and the struggles today, and will eventually fight their own struggles to achieve their vision of justice, equality, and freedom. And there are many ways through which you can do this. So a human rights person can be an academic, can be a researcher, a lawyer, an activist, a judge, a politician, a journalist. They can work at international or national level with NGOs, with international organizations, can also work in specific fields. So rather than working on human rights broadly, you can specialize in a particular field within human rights. It could be economic, social, and cultural rights. It could be the prohibition of torture. It could be migration-related human rights. So I would really like to conclude, in a sense, with a question. And you can answer these questions, it's an open question, by going at the link at the top of the slide, which is paulev.com/noemi-magugliani495. And you can type in, it's a curiosity from my side, but also a reflection exercise on your side. So which human rights issues are you interested in? Again, personally, while you might make up your mind on this question, for me, it has always been migration. From the very beginning of my undergraduate career, I've had an interest in migration and asylum law, and a particular interest in the way in which the law, which sometimes we use to make change and we use to hold governments to account, sometimes the law is the problem. Sometimes the way a law is drafted and not implemented is something that might impact negatively on our human rights. So that has always been my focus. Then over time, it has changed. It has narrowed down until I found it always seems a bit odd to say, but my happy place in anti-trafficking law. But that shows that human rights are interconnected, they're interlinked, and if you achieve one disregarding the other, that particular disregard of something else will impact the human rights you're fighting for, really. So they're all, it's an ecosystem of them. Now, I know I can't really see on Teams there, but I do think my time is up. I can't share the slides anymore, but if you want to answer these questions even later, I would be really curious and happy to read them later on.
Great, thanks very much, Naomi. Unfortunately, we actually couldn't see the link on the top of the slide. It got cut off, but not to worry. At least students can have a think about maybe what areas they're interested in. But thanks very much, Naomi. That was really interesting. We will now have a short break, and we will be back here at 12 o'clock, and we'll have 2 more taster lectures on what is criminology. And we'll also have another taster lecture on robot judges and robot lawyers. Oh my. So we'll see you back here at 12 o'clock. Thank you. Welcome back everyone to our Law TUI Taster Day. We have our final 2 taster lectures. The next one is on what is criminology, and then our final taster lecture will be on robot judges and robot lawyers. I would now like to introduce to you Dr. Dermot Griffin. Dermot is a lecturer and programme director of the Law BCL Criminology and Criminal Justice Programme at NUI Galway School of Law, and is the author of the leading book Killing Time, Life Imprisonment and Parole in Ireland. So over to you, Dermot.
Thanks, Lisa. Hopefully you can see me and hear me there wherever you are. So I'm just going to give you a quick talk today about what is criminology and what do criminologists do. And as Lisa said, I'm the Programme Director of the Law, Criminology and Criminal Justice Programme, which we run in the law school here at NUI Galway, which gives you a full law degree, but also gives you a specialisation in criminology and criminal justice. Okay, so what is criminology and what do criminologists do? Well, criminology really is a subject that covers, law, psychology, sociology, politics, medicine, and really criminologists look at one simple question: why do people commit crime? What factors influence a person to break the rules? What factors influence a person to break the criminal law? And also, criminologists look at what happens to a person when they do break the rules. So how does society respond to a person who is deemed to be a rule breaker? And also, criminologists ask questions, at a more deeper level. They say things like, well, why is it that men commit more crime than women? What is it about the male that makes him so criminogenic? Why is it that the prison system seems to replicate populations from a lower socioeconomic background? Why is it that white-collar criminals don't end up in prison, whereas ordinary criminals do end up in prison? So they're the kind of questions that criminologists tend to ask when they're looking at the crime problem. And you can look at it from lots of different perspectives, lots of different disciplines, and that's what criminology is about. So even though you might be studying criminology in the law school, you'd be exposed to lots of different disciplines, including psychology, sociology. In terms of my own work, I'm from a law background, but I focus on sociology and in my work. So there's a whole range of different kind of approaches to look into the crime problem. And I'm going to talk a little bit about that with you today. The first thing is, and first thing that criminologists really look at is, what is the criminal law and what do we deem to be a breaking of the rules? You had other talks from different lecturers in law earlier on today and later, I'm sure, but criminal law is a little bit different from other laws in the sense that, a criminal law is a breach of the social order. So we as a society say that this type of behaviour is not acceptable, and we kind of all agree these are bigger rules than maybe a kind of a civil law kind of situation or a kind of an accident that might happen. You might sue somebody. When you break the criminal law, the society itself responds and punishes you for it, right? So when we ask this question, you can see the picture here. Why is this not a crime? Somebody is effectively assaulting another person here, but because of, strangely and weirdly, because there's grass underneath them and white lines around them and they're wearing jerseys, people don't view it as a criminal offence, and society doesn't view it as a criminal offence. It might be a breaking of the rules of the sport, but as a whole, society doesn't view this kind of conduct in this kind of context, and the context in criminal law is very important as a criminal offence. If we saw this on the street and people were wearing ordinary clothes, or even if they were wearing the clothes that they're wearing in this picture, people would be probably offended by it, shocked by it, and would call the Gardaí. But on a green pitch, people are entertained by it. And that gives us an indication that, it's not just about the actions of the individual, it's about the context in which the behaviour happens. And also, underlying a lot of criminal law is the issue of consent. So where people are consented to engage in certain kind of activities, we say that this might be lawful, but there are limits to that. And of course, even in sport, if somebody does assault someone in a serious way, that can be deemed to be a criminal offence, irrespective of the fact that they're both agreed to participate in the sport. So criminal law isn't just about something that exists and that we all agree and it has existed forever. It changes over time, or perceptions change over time. So in this context, there's a lot of research coming out about rugby and the medium and long-term effects, cognitive effects on rugby players, and indicating that the violence that they experience on the pitch is something that we might have to change. The rules of the sport might have to change. We will no longer tolerate this level of violence. So, as society progresses, oftentimes our perspectives on what is acceptable in sport and outside of sport can change. it also tells us a little bit that, you know, crime isn't something that is static, but it changes, it's dynamic. And the criminal law is something that we create as a society, but we also change it. We create new crimes, but we also repeal other crimes. And there's lots of examples of that in society. I'm just giving you 3 examples here. One would be the repeal of the 8th, the referendum recently, a couple of years ago, on abortion. Previously, it was a criminal offence to procure abortion. Now, it was the case that I don't think anybody had been prosecuted under those offences for a long, long time. And ultimately, you know, there was a referendum and it indicated that the public did no longer supported this being a criminal offence, right? So if the public doesn't support the criminal law, it really has no legitimacy in the society. Similarly, with up to 1993, it was a criminal offence for 2 men to consensually engage in sexual activity, and this was repealed in 1993 because the society no longer accepted that. 30 or 40 years ago, people were frequently prosecuted for this kind of conduct, and society changed, developed, and viewed that this was no longer acceptable, and the rules changed as a result. And going back a little bit further, you might have heard of, I don't know if you've ever heard of speakeasies. They're kind of popular now as a gimmick, but in America, they outlawed the production and sale of alcohol, so that nobody in America can produce, sale alcohol, and also consumption of it. So that meant that all of a sudden, when those rules changed, it meant there was a huge category of people who could potentially be criminals that weren't previously. And then when the rules changed again, they also weren't criminals after that. So you can imagine if you decriminalize the possession and sale of what are currently illegal narcotics, you know, we would decriminalize a whole group of people that currently are in the prison system. So there are changes that can happen in relation to criminal law that can have a big effect on who is captured by the criminal justice system and who ends up in the criminal justice system. And it's not something that's stable necessarily. As society changes and our views change and what we deem to be acceptable changes, so will the criminal law follow, you know. So that's an important area for criminologists to look at. Another thing that criminologists often look at is this question: is society becoming increasingly violent? And criminologists try to measure this in lots of different ways. And you might be forgiven for thinking that you know, society is becoming increasingly violent because we are exposed to so much news and media about crime and violence. It's overrepresented in our media. If you look at all the news we consume, and you know, all these documentaries, crime documentaries, there's a kind of a mainstream cultural obsession with crime. But that doesn't necessarily mean that crime is more prevalent or that society is becoming increasingly violent. One way of looking at that is to ask people, and you can see here in a survey, 83% of those surveyed by the Central Statistics Office believe that crime was a serious or a very serious problem. And this taps into what we call the fear of crime. So criminologists are interested in measuring how people feel about crime and what they perceive as the crime problem in society. Okay, and oftentimes the public will report that they view crime as a very serious problem, and they often tend to say that they feel that the criminal justice system isn't adequately dealing with the crime problem. Okay, so there's kind of a twofold approach there, and it taps into maybe a perception of the fear of crime. But interestingly, when we ask them at an individual level, you know, do you fear crime in your daily life? You know, are you worried about crime? Are you concerned about crime in your community? And what kind of crimes are you concerned about? A lot of respondents will say that they actually don't worry about crime on a daily basis. They don't worry about becoming a victim of crime, 63% of people here. And in some studies, it's actually even higher than that. So a lot of people, even though they feel that crime is a serious problem, most people feel that it's not a serious problem in their everyday life, or they don't fear becoming a victim of crime on a daily basis. So it gives us an idea that maybe asking people isn't a good way of measuring whether crime is increasingly prevalent or society is becoming increasingly violent, because people have kind of unusual perceptions about what is happening in society and whether crime is increasing or decreasing. And we tend to, as people, think that the past was a more safer place and a more kind of you know, there was less crime when our parents were growing up or things like that, you know, so that people sometimes have that perception. But in actual fact, society is we have never been as safe as as a society, you know, if we take a long-term view of things. Okay, so this is a graph looking at homicide rates in Europe from the 13th century, so 1200 to 2016, and it indicates to us fairly consistently across lots of different countries that the homicide rate, which is a good measure of whether society is becoming increasingly violent or not, and the reason it's a good measure is because when somebody's killed, you know, the body is identified and is deemed to be unlawful. Other crimes maybe aren't reported by people. They say if it's a sexual offence, a lot of people don't report those types of offences. But with a homicide, because of the nature of the crime and that there will be a dead body, and that will be classified as an unlawful killing in some circumstances, it's a good measure of what's actually happening in terms of violence in society. And you can see here that the graph indicates that crime is decreasing over the centuries. Now you can see that it goes up and down at different stages. And if we were to look at different periods of society, we might say there was a spike in crime in this decade or the previous decade. We've seen that in Ireland also, with the rise of gangland crime, certainly in the 90s and the early noughties. There was a big spike in homicide rates, but that seems to have fallen off in the last decade or so. But it may arise again, depending on the circumstances that's going on in society and what's happening in our culture and in society at that particular time. But overall, the evidence suggests to us that if we take a long view of what's happened in society, we could say that crime is less prevalent or violence is less prevalent if we use homicide as a measure. And that's what criminologists say it's called the civilizing process, that as we develop as a society, we have become more civilized, violence is less tolerated, and the structure of society impacts the likelihood of violence as we have progressed as nation states. Here's a map of the world, a different kind of colored map than maybe what you're used to, but it also gives us information about homicide rates from country to country. And you know, this is a really important graph and picture here, because it gives us a bit of information about how homicide rates can change depending on the society and the country in which you live, which is important because oftentimes, and we'll talk about this in a moment, oftentimes we think about homicide as an individually motivated crime. Somebody wants to kill someone for financial gain, or somebody simmered over and lost control and killed their partner. We think about at an individual level, but this tells us actually that homicide can be affected by the society in which we live in. You can see European countries there have a much lower homicide rate than a lot of the Latin American countries and the Central American countries. You can see two countries I'd point out there with a high homicide rate will be Venezuela and Colombia. And you know, what factors might be influencing a higher homicide rate there? Well, it could be the illegal drugs trade in Colombia. That could be an influencing factor that might be driving certain levels of homicide in the country. And in Venezuela, we might say, well, there's a lot of civil conflict in Venezuela over the last decade. And so that can have an effect on the homicide rate. So it's not just about individual motivations. Criminologists look at trends generally and try to say, well, what's happening in society generally, and how does that affect the levels of crime in a society? And that's a really important thing to unpack, because it also means that a lot of countries could maybe reflect the lower rate of homicide if they were organized differently. Just looking a little bit more deeply about some of those factors in terms of homicide, we can see, and this is relevant really at the moment with the war in Ukraine, you know, armed conflicts and organized crime can have a big role in the levels of homicide globally, and of course in the individual country. You can see armed conflicts and organized crime really are responsible for the same amount of deaths, really, 1 million deaths for armed conflict and 1 million deaths for organized crime, which is interesting because maybe people might think that armed conflict would be higher in terms of the number of deaths, but actually organized crime has a very serious impact on society. This also gives us an idea, well, if we have better control on organized crime in a society, if we are better at eliminating organized crime into society, we can also affect the homicide rate. Similarly, if we have less armed conflict, which, you know, most countries do not want armed conflict in their country and don't desire it, has a huge impact on, as we're seeing play out in the last couple of months in Ukraine, you know, this is a major impact. And of course, maybe you've read from the news that allegations of war crimes being committed in Ukraine, by Russian forces. And those individuals, it's not just a matter for the country that's invaded Russia, but individuals are also responsible for their actions. There is no justification for any kind of war crimes, irrespective of the orders that you might have from higher up in the ranks of whatever rank you're serving in. So there's a lot of kind of issues that kind of arise there as a result of armed conflict, and unfortunately we're seeing it play out at the moment. Let's look at individual motivation. So there are kind of some kind of global factors that might influence the homicide rate, but what influences an individual to commit crime? Well, you can see that the primary motivating factor, at least in Ireland, is anger, quarrel, or rage. Most people kill another person in the heat of the moment, usually as a result of an argument. It can often happen in a domestic context, but doesn't necessarily, it's not always the case, but it's usually as a result of an argument that got out of control. It's not necessarily premeditated in most circumstances, but there are other factors, things like revenge, robbery, which is more of a premeditated type of crime. Even though you mightn't intend to kill the person, you might intend to use violence to secure the goods that you're trying to gain, or it could be a sexual motivation, it could be an accident, it could be organized crime. Organized crime is actually quite a higher up in terms of the percentage there, but for the most part, homicides are committed, in the spur of the moment as a result of an argument that gets out of hand and one person uses lethal violence to kill another person. Okay, so there's kind of a perception sometimes that homicide is premeditated. It can be, of course, but isn't always. It's usually the heat of the moment. And a big factor in that, in homicide generally, is the use of psychoactive substances. Okay, so psychoactive substances, including alcohol and other drugs, can have a huge impact on the level of violence in society. And this is also can be tied up with the nighttime economy, and we can see that actually. And measure that also. Criminologists often measure what the effect of the consumption of alcohol and illegal substances in the nighttime economy and its effect on violence on the streets, as maybe in at certain hours of the night. Okay, so alcohol and illegal substance use can feed into that. You can see that 37% of people who were perpetrators in homicide were under the influence, and the vast majority of that was under the influence of alcohol. Only 6% were under the influence of drugs. So this indicates to us that alcohol can play a large factor in violence against other people. And sometimes you might say, would these crimes have been committed but for the consumption of alcohol in these circumstances? Another thing that's interesting to look at in the homicide category as a factor in the perpetrating of homicide and violence is how people commit homicide. And you can see there 54% committed homicide using a firearm. 24% uses kind of lots of different things, lots of different means of violence. 22% uses a knife. So 54% using a firearm is fairly significant because, of course, we know as a society it's important to restrict access to firearms. And so it tells us that actually the policies that we have, the rules that we have in society in relation to access to certain weapons can potentially impact the level of violence in society. If you look at the US, they have quite a permissive approach to violence or to access to firearms, and they also have a higher homicide rate. Are there correlations that can be drawn there between those two things? In Ireland, we have a more restrictive approach to access to firearms, and that it serves the interests of the public. So these are kind of public policy decisions to protect society as a whole, because we know access to firearms can lead, won't necessarily, but may lead to some level of violence. So that's just looking at kind of homicide and some of the factors. And really the point is that, we can look at the issue, the question of, is society becoming increasingly violent from so many different perspectives? We can look at it globally, we can look at it individually, what different motivations people have. We can ask people how they feel about it. And that's what criminologists do. They don't just look at, let's say, an individual crime. They try to identify patterns and trends in relation to what's happening in society, what is happening, and what can we say about it? How can we analyze it? And maybe also, can we propose changes to public policy and laws that can make society less violent, or to reduce levels of violence in society, or eliminate crime maybe altogether? Some criminologists believed at a certain point that we could do that. Another question just to move on, I don't want to run out of time, maybe I'm running out of time here, is are people genetically predisposed to crime, or are environmental factors more important? And, you know, criminologists used to believe that it was people were, for example, born criminals. So that was kind of the origin of criminology. There was a view that people were predisposed genetically to commit crime. But throughout the 20th century, there were lots of criminologists that began to question that approach to the crime problem. And they viewed that actual environmental factors had a large impact on people's behavior. And so your environment in which you grew up in, you know, your parents, your siblings, your age, your access to education, your socioeconomic background, they can all influence how we deal with life, how we react to certain situations, and what impact and what likelihood factors are going to influence us to potentially break the rules. It's also to say that a lot of us will eventually, or at some point, break the rules in a minor infraction of the criminal law, where none of us are immune to that. If you want to find out a little bit more about the environmental factors, there are two famous experiments that criminologists conducted, the Milgram experiment and the Zimbardo experiment. You can look them up on YouTube, but they were post-World War II experiments, and they kind of identified that people could, if they were given orders, would act in ways that were totally shocking, indicating that people were very capable of committing violence and abuse under certain circumstances. So if there's a structure there that permits and accepts violence in society, it can actually affect people's behavior in a major way, and very normal people, quote unquote, can commit very abnormal acts. If you found any of that interesting and want to find out more about it, you can learn all about that on our website, in the Law, Criminology and Criminal Justice website, or contact law@anywaygo8.ie. Hope you enjoyed the talk and enjoy the rest of the day.
Great, thanks very much, Dermot, for that presentation. Our last taster lecture is on the topic Robot Judges and Robot Lawyers, oh my. And this will be presented by Dr. Ronan Kennedy. Ronan researches and teaches environmental law and information technology law. He also teaches the optional module Law and Innovation, which is offered to undergrad students in final year. And this module provides students with the ability to understand the relationship between law and technology. And I'll now pass you over to Ronan. Thank you.
Thanks very much, Lisa. And if everything's working in order, you should be seeing my screen and my slides are on now. So I won't keep you for all that long. I think you've had a long morning, and I'm the last presenter for the day. But as Lisa mentioned, one of the things that I teach is a module on law and innovation. So I'm going to present some of the material that I present in that context, and try and give you a taste of the sorts of things that you might touch on or learn about if you were to take that module, or also some of the issues that I touch on in the information technology law module that I teach. And really a lot of my teaching and my research is about figuring out what is the impact of all of this digital technology that we're surrounded with, that I would guess probably a lot of you take for granted to some extent. It's said sometimes that technology is anything that's invented after you're born. Although a lot of the digital technology was there when I was born, a lot of what we're using now, and internet and artificial intelligence and so on, is very much new. But to you, it might be something that's just part of your daily lives and you don't think about it necessarily an awful lot. And I'm going to try and maybe get you to think a little bit more about that. As I say, indicate some of the ways in which I deal with this and encourage my students to reflect on it as well when I'm teaching. A lot of this work is actually based on research I did for the Oireachtas. I was what's called a research in residence, funded by Science Foundation Ireland. So there's if you want to know more about this, there is actually an extensive paper on the Oireachtas website. But I mention that because I'm going to come back to that towards the end of the presentation. To begin with, though, I just want to, I suppose, give you a little bit of a context for this. And before I do that, I'm going to try something. We'll see if the technology actually cooperates with me. If the technology is cooperating, then you should be seeing a Slido question there on your screen. I think this was used in some of the earlier presentations and seemed to have worked okay. So the question I'm just asking you to initially is just to ask, whether or not you've ever been in a courtroom. I think in a lot of cases, students are in a classroom and don't have answers or access to their phones, but maybe whoever's can get online can present sort of a majority class view. I'm not asking why you were in a courtroom. I'm just asking whether or not you have actually been in a courtroom. So there's a number there on the screen, and you can just type that into slido.com, which I think you were using earlier today as well. I'll just give you a minute for people to put in responses to that. Okay, so the majority so far seem not to have ever been in a courtroom. And that's fine. I guess if you haven't had a reason to be in a courtroom, then perhaps that's perfectly good. But I would suggest to you, maybe if you've been in any way intrigued by what you've heard so far today, or if you're generally been thinking about the law and the law as a career, a courtroom is something. A courtroom visit might be something that would be good to try out. They're free. They're generally open to the public, except for certain types of cases. Family law and sexual offences cases tend to be closed, but otherwise, generally anybody can go in. Depending on the day you pick, they can be quite entertaining, quite interesting, and if nothing else, you get a sense of what the law looks like in practice, at least in that particular way. There's a lot more to legal practice actually than what you see in court, but at least you'll get some sort of flavour of it. Okay, so most have responded there, and see clearly that a lot of you, okay, it's coming a bit closer, but a lot of you haven't been in a courtroom. So try that maybe afterwards. Now I'm going to close this poll so that I can move on. And the reason I asked this question is, first of all, just to suggest that to you as something to do, but also to give you a bit of context for the research that I'm doing and the teaching that I do. And if you can imagine for a moment that you were able to take a doctor from, let's say, Dickens's time and drop them into a modern hospital, that person would be completely confounded by all of the digital technologies and tools that they would see. But if you were to drop a lawyer from Dickens's time, that person would, I have to admit, actually be almost certainly male. He would be very comfortable with what they would see in front of them. The courtroom really doesn't look or feel or operate that very differently to how it did in Dickens's time. And a lot of the rules of procedure and the types of practices and the way in which cases are argued are the same. And what particularly would not have changed very much is the use of technology. There is some technology in Irish courtrooms and other courtrooms, and if you do go, you'll see laptops and you'll see computers on the bench and you'll see digital audio recording facilities. But there's nothing on the scale of what you'll see in we'll say a hospital to take that as a point of comparison. But that's all really changing now and changing relatively quickly. And as the title of my presentation hints at, I suppose, we're now looking at a situation where people are really seriously considering, and in some countries actually acting on and implementing, replacing lawyers and replacing judges with robots, quote unquote, not with things that look like people, but with software programs, artificial intelligence programs that can answer legal questions. So I just want to talk about that, I suppose, a little bit and see what that means for us, what that means for law, what it might mean for the study of law, what it might mean for you in terms of future careers, and whether or not you might find any of that of any particular interest. So what I'm talking about here is a thing that's generally called law tech, or sometimes called legal tech. It's given a couple of different labels, and it's technologies that aim to support or supplement or replace traditional methods for delivering legal services, or that improve the way the justice system operates. That's one definition. That's from a big report that was done in England and Wales a couple of years ago. And this is a diagram I put together trying to explain what these things look like. Now, I'm not going to go through the detail of this. A lot of what's on the bottom of the screen there, office support, court support, these are not necessarily hugely interesting. These are, in a lot of ways, standard technology tools that are used in a range of other types of professional work, different walks of life. They're just being repurposed for use in the legal and the court context. We have a lot of focus on locating information. Law is maybe the original information profession, and we have actually used online databases and search tools and so on, primitive versions of Google, I suppose, since the 1950s and the 1960s. But again, they're really just better, faster, more convenient libraries. The thing that's really interesting is to look at the stuff in orange there, the independent decision making. And here we have tools that actually really supplement the way in which law is traditionally practiced. So you have a software program that might be trying to negotiate with the other side. You might be replacing an adjudicator, it could be a judge, it could be an arbitrator with a software program. You could actually have legal tools, and there are people who are developing legal tools where you can feed a set of problems, you can feed a set of legal paperwork to, and it will draft a response to the other side. It will tell you these are the good arguments, these are the cases you should cite, this is how you should run your argument at court. This is the chance you're going to lose this case, so maybe you should think about settling it. And also one of the things that I work on with my students is what are called chatbots, which are, I'm sure you've come across these kinds of things when you're using online shopping sites and electronic commerce sites, where a little box will pop up and go, do you have a question? Ask us now. Instances which are interacting with that, and at least in there, at least initially, is not actually a person. It's just a robot. Basically, it's a piece of software. But people are developing these kinds of bots to provide answers to legal questions. And it's one of the things that I actually get my students to do to give them that hands-on experience. So this sort of thing could actually matter quite a lot in terms of the Ireland as an economy for two reasons. One, it's a potential new sector, a lot of potential business in this, a lot of money being invested in this, a lot of money being spent by big legal firms on using these kinds of tools. But also because you're probably aware that legal advice is quite expensive. So there is a possibility that actually by replacing people who are expensive with software programs, that we could actually lower legal costs quite a lot, which would be important and useful. So there's a couple of different ways in which this could happen. I already talked about the possibility of documents being created electronically. So you could tell a software program, here's the basics of my dispute, or here's the basics of my negotiation, or here's the basics of the contract I want to create. And the computer program will put everything together, and all you need to do is sign it. Saves a lot of money. Conveyancing, this is the sale, the purchase and the sale of land, very bread and butter, very common transaction, and is often quite expensive and slow. Although a lot of it is standardized and could be standardized. So maybe electronic conveyancing might be an option. Now, it turns out that it's maybe more expensive than we think to do that, and a lot of money has actually been spent on a fail system in the Irish context. And then people talk about predictive contracting, where you basically tell a computer program, here's my experience with contracts, and here's the kinds of contracts where, or the kind of contractual situations where we end up in litigation, we end up in court. Can you help advise on better clauses to use, or where the risks are, where we should really pay attention? Or, the other side have sent me a contract, it's 50 pages long, I'm not going to read that in detail. Computer program might say you need to read this clause, and this clause. The rest is just standard boilerplate. Saves a lot of time. And when you're charging that time at 150, 200, 500 euro an hour, which you can be charging at, then that's a significant potential saving. What's also quite interesting, and one of the things that I focus on quite a lot, is whether or not this might have good social implications, because it could give people better access to justice because that access is cheaper. And I'm going to pause for a moment, and again, assuming the technology works, I'm going to ask you another poll question. So if you're given the choice between getting legal advice from a person, from actually going to a real live lawyer in their office, or as people were doing during lockdowns over Zoom or whatever, or would you prefer to get that advice from an app on a website or on a mobile device or something like that? Which do you think might be your first choice? Again, maybe just a general consensus in particular classrooms. So we're about neck and neck. Oh, app is in the lead. Well, not quite in the lead, but catching up. So, you know, there are advantages and disadvantages. An app could be much cheaper. It might be free, particularly for initial consultation. It might be free. Certainly a lot more convenient if you can do it outside of hours, if you don't have to go somewhere. Person might be quite expensive, but then there's the question of, is an app going to ask all of the right questions? Is the app going to put all of the pieces together? Are they going to think of asking for the piece of information that is quite relevant, but you might not have told the human? Story about 50-50, give or take, I guess. So, you know, that's and actually quite an interesting result for me from a research perspective, because this is one of the questions that people have. You know, yeah, if we have all these apps and people can just log on to their phone or log on to a website, then everybody can get access to lawyers. And maybe that's not so good for lawyers, but it's good for the world in general. But actually, research does indicate that the reasons why people don't get legal advice are often not necessarily to do with the cost. They're more to do with their comfort with getting legal advice in the first case, with knowing that they have a legal problem, with knowing how to deal with it. One of the major places where people don't have proper legal advice is in terms of drafting wills. But the indications are that actually most people don't draft wills not because they don't want to talk to a lawyer or because they're not willing to pay for it, but actually because they don't want to actually sit down and think about the fact that they're going to die. And they particularly don't want to think about the challenges of, well, what happens to my estate? What's going to happen to my house or my land? Or how do I decide which of who my family gets this? So there are bigger questions, I suppose, than the technology. And this is one of the things that I talk about in my teaching, is that, you know, we need to look beyond thinking that there's a magical, technical, logical solution to all of our social problems. This technology also has some issues in terms of the ethics of whether or not they should be used. The pandemic was particularly interesting there because the courts in this country and in many other countries went online to a significant extent, or almost entirely. And it worked reasonably well for the most part. And actually some aspects of that I think are going to be retained, because for, you know, routine cases and commercial law cases and so on, remote hearings are actually quite good. They're cheaper, they're more efficient. But particularly the judges I talked to really didn't like it. They wanted lawyers, they wanted witnesses in the court so they could really see them, they could hear them, they could interact with them in a much better way. And there are implications in terms of whether or not particularly criminal defendants are disadvantaged if their case is being heard remotely. You know, is somebody really understanding what's going on when it's on screen? So that is a thing that needs to be considered. And then there are questions around whether or not there are issues in terms of bias with the use of these types of tools in the to support judges or to replace judges. And there are indications, particularly from a lot of research that's been done in the US on AI tools that help to support judges with sentencing and bail decisions. It turns out these AI tools are often tougher on black defendants than white defendants, basically. Now this is where it really gets interesting, because these tools are not programmed that way. It's not that the programmer sat down and said, we're going to be tougher on black people rather than white people. It's that the data that they're relying on, the historical data, has all these patterns of behavior, of biased behavior that's historical, and that's built into the data. So if you're using an artificial intelligence tool, which is often machine learning, which is really no more than sophisticated statistical modeling, it's going to repeat the bias in those statistics. And that's where it gets really problematic. Do we really want to have those patterns of bias reproduced? So I'm going to go through this relatively quickly. I spend a lot more time on this when I teach it in class, but you know, we talk about whether or not we need to regulate this technology. A lot of it just operates without any rules. We talk about whether or not some of this might actually replace the legal profession. Whether or not we might end up doing away with solicitors or barristers. We have in Ireland general prohibitions on people pretending to be or holding themselves out to be solicitors or barristers, and there's certain activities that are reserved to solicitors. But there's a sort of a grey area where you've got these software startups that are developing websites that help to, let's say, draft wills or draft divorce documents. Are they actually breaching these prohibitions? Do they need to be regulated in some way? We don't know the answers to these, and these are really interesting questions that are live questions right now, and where actually I'm seeing our students and our graduates really contributing to that, because they're starting up these companies. and they're doing the real work, I suppose, that I'm just helping them getting started on. So there are questions around whether or not we should be regulating software engineers, whether we should be regulating AI engineers. I'm not, you might be thinking at this point, well, maybe I should be a software person rather than a lawyer. I'm not saying that. I don't think that lawyers are going to go away anytime soon. I'm actually instead thinking, well, maybe we need to be looking at these new lines of work that we don't regulate in any meaningful way at all, but actually have huge ramifications for society. So much of what we do now is mediated by digital technology and by artificial intelligence, and we've no real rules. I can set myself up in the morning as an AI engineer without needing any particular qualifications. So there's interesting questions then about whether or not we should use these types of tools in a courtroom context. Online dispute resolution could have huge benefits in terms of making access to justice, particularly for, we say, things like small claims and so on, cheaper and easier and quicker. And there are jurisdictions like China, which actually are beginning now to replace judges with artificial intelligence tools. Estonia has talked about doing this, although I don't think that they've really actually done it. I think it's been more of a press release than a real technology. But that raises, this question I've already talked about. If we're going to use software to substitute for some or all of what judges do, is that necessarily a good idea? And I'm just going to throw up another quick poll for you. This is the last one. Nearly finished with this presentation, but would you be comfortable with an artificial intelligence program deciding court cases? How would you feel about robot judges if we were to have them? It's a strong vote against so far. Okay, so this is interesting, very clear so far that no one really thinks that AI programs should be replacing judges anytime soon. I thought there might be 1 or 2 votes for yes, because some people say that, oh, well, okay, we've got some votes for yes. Some people say that AI tools and software tools could be actually more reliable, could be less biased, wouldn't be as influenced, because we all have biases, we all have prejudices of one sort or another. And so maybe you could program an AI tool to be invulnerable to those. And so this is to say that it's really not possible. And that there's something that a human can bring that you never really program into a software tool. So it's interesting that most of you feel that way, but some don't. So anyway, that's one of the things that, again, we think about. It's actually something that students this year were writing an essay for, or on for me. And it's the kind of things that you might get to explore when you get towards later in your course. I'll just finish up, I suppose, on this brief note. I mentioned at the beginning that I did a lot of the original research that has informed this for the Oireachtas. Actually didn't end up going to Leinster House of lockdown, although I was supposed to be there. But one of the things that I came across in my research is this idea that in time we might actually write legislation so it's more easily translated into software. And that would be also quite a significant change. This would mean then it would be easier to automate things. It would be easier to use AI to implement these new schemes of regulation. And one of the things I'm supposed to do as part of my research and residence role, and hasn't happened yet because of COVID, is to present this research to the Oireachtas. So I'm curious to see how they feel when I will suggest to them that perhaps we shouldn't do away with lawyers or judges. We can't replace those with robots, but perhaps we could actually replace legislators with robots. I'm not sure how well that's going to go down, but anyway, I'll try it with them when I get a chance to talk to them. So I suppose to conclude, this is a wide open areas of long quote there. I'm not going to read that out in detail. This is really a very dynamic and developing area of law and legal practice. And I work with students in modules like Law and Innovation and a new module called Law and Analytics, looking at these questions, looking at how these new technologies impact on legal practice, how it's really been shaken up after centuries of being very, very similar. What are the new career opportunities there? What are the things that lawyers need to be aware of? And how can we make the best use of this technology for the good of society as a whole? So I will leave it at that. I think I'm a little bit over time. I'm keeping you from your lunch, I'm sure. But thanks very much for your attention. If you're interested in more, there is a spotlight paper on the Oireachtas website. That link to it is very, very long. But if you're really interested, you can look that up there. Or if you want to get in touch with me with any follow-up questions, my email address is there on the screen. So thanks very much, and I hope you found this morning useful and interesting. And it helps to guide you towards making your career choices in due course. And don't forget my suggestion that you're interested in a career in law, then 20 or 30 minutes sitting in a courtroom watching what's going on is really quite a valuable and eye-opening experience. Thanks very much.
Great, thanks very much, Ronan, for that very interesting presentation. I'd like to thank everyone for their attention today, and I hope that you found it useful and insightful, and I hope that we may welcome some of you to NUI Galway in the future. If you've any questions about studying law at NUI Galway, please feel free to email law@nuigalway.ie. That's law@nuigalway.ie. The recording from today's taster lectures will be available on the NUI Galway YouTube page and also on the NUI Galway Taster Days website. So thanks very much for your time, and hopefully we will chat to some of you in the future. Thank you.